Good morning, students. Welcome to the next session. What we are having today is the continuation of the last discussion what we were having about joinder and splitting of claims and splitting of reliefs. We said that once a plaintiff files a suit, he should join all the causes of action, or he should if one cause of action is there, he should not split the cause of action, he should not split the claim, he should not split the reliefs, and it should be that he brings all the things in the suit which he wants the court to decide, so that there will be a finality to the decision. That was the summary of what we were discussing in the last session. So today there is one thing which we have left out in order to, that is joinder of causes of action. Suppose there are number of instances or number of times when the cause of action has arisen to the plaintiff, and out of each cause of action there are reliefs which he can claim, or there are remedies which he can claim before the court. Then if he files a suits for different causes of action at different times, again there could be multiplicity of suits. So this rule 3 of order 2 says that joinder of causes of action can be done save as otherwise provided. That is one word which is given in the beginning, save as otherwise provided. A plaintiff may unite in the same suit several causes of action against the same defendant, or the same defendants jointly, and any plaintiffs having causes of action in which they are jointly interested against the same defendant, or the same defendant jointly may unite such causes of action in the same suit. So this looking at that rule, it is a little bit lengthy rule, and we have to split it into parts to understand the meaning of this rule. See, joinder of causes of action, number one, first, whether the causes of action can be joined. Secondly, the jurisdiction of the court regarding the suit shall depend upon the amount or value of the aggregate subject matter of the date of instituting the suit. It says that the jurisdiction of the court will be decided according to the aggregate value of your suit. So looking into these 2 points, that whether the cause of action can be joined together in one suit, we are going to discuss this in detail. Now the first thing what we have looked into is this is rule 3 and rule 6. Okay, rule 3 and rule 6, first of all, rule 3 enables joinder of several causes of action in one suit in certain circumstances subject to the provisions of the code. It says that save as otherwise provided. Rule 3 sub rule 1 says save as otherwise provided, means joinder of several causes of action in certain circumstances subject to the provisions of the code. What are those provisions? Which we have already discussed when we discussed about the joinder of parties. We see rule 1 and 3 of order 1 was discussed, and rule 4 and 5 of order 2 also we have seen. Rule 4 is when recovery of immovable property can be done if it is if we have to join the causes of action, then what has to be done? See, when there is recovery of a property, only 2 things are there. One is he can claim only for a particular category of remedies, that is the person can, what can be joined? See, claims for mean profit of arrears of rent and claims for damages for breach of any contract. Okay, this can be joined, and claims in which the relief sought is based on the same cause of action, all that can be joined together when there is immovable property. That is rule 4 of order 2. Rule 5 speaks that claims by or against executor, administrator, etc., that is personal claims of the executor or the administrator, when he sues on behalf of the estate of the testator, then he cannot join his personal claims. He cannot join his personal claims, except that where it will be that it is part of that estate, or it arises out of the things he has done for that estate only. That claim arises out of that. Or secondly, where he is in jointly liable to any other person along with the deceased person in that particular case, then only he can join the cause of action, otherwise not. So subject to this rule 4 and 5 and subject to order 1, rule 1 and 3. Order 1, we have seen how joinder of plaintiffs can be done under rule 1 and how joinder of defendants can be done under rule 3. So these are the 4 things which we should consider when joinder of causes of action has to be done. ಈಗ ಕಾಸಸ್ ಆಫ್ ಆಕ್ಷನ್ ವ್ಯಾಜ್ಯದ ಕಾರಣ ಜಾಯಿನ್ ಮಾಡಬೇಕಾದ್ರೆ ಎಲ್ಲ ಸೇರಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದಾಗ ರೂಲ್ 4 ಮತ್ತು ರೂಲ್ 5 ಆರ್ಡರ್ 2 ಆದೇಶ 2ರಿಂದ ರೂಲ್ 4 and 5 ಅದನ್ನು ಗಮನಕ್ಕೆ ಇಟ್ಕೋಬೇಕು. ಮತ್ತು ಆರ್ಡರ್ 1 ಆದೇಶ 1ರಲ್ಲಿ ನಾವು ಪಾರ್ಟೀಸ್ ಜಾಯಿನ್ ಹೇಗೆ ಮಾಡಬೇಕು ಅಂತ ನಾವು ಏನು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಿ. ಅದರಲ್ಲಿ ರೂಲ್ 1 ಪ್ಲೇಂಟಿಫ್ಸ್ಗೆ ಸಂಬಂಧಪಟ್ಟಿರೋದು, ರೂಲ್ 3 ಡಿಫೆಂಡೆಂಟ್ಸ್ ಸೇರ್ಪಡೆ ಮಾಡೋದು, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಜಾಯಿನ್ ಮಾಡ್ಬೋದಾ ಅಂತ ನಾವು ಡಿಸ್ಕಸ್ ಏನು ಮಾಡಿದ್ವಿ. ಆ ರೂಲ್ಸು ಸೇರಿಸಿ ಅದಕ್ಕೆ ಅನುಗುಣವಾಗಿ ನಾವು ಈ ನೆಕ್ಸ್ಟನ್ನ ಜಾಯಿನ್ ಮಾಡ್ಬೋದು. ಬೇರೆ ಬೇರೆ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಇದ್ದರೆ ಬೇರೆ ಬೇರೆ ವ್ಯಾಜ್ಯದ ಕಾರಣಗಳನ್ನು ನಾವು ಸೇರ್ಪಡೆ ಮಾಡಿ ಒಂದು ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ಬೋದು. ಇದರಲ್ಲಿ 4 ಸಿಚುವೇಶನ್ಸ್ ಬರುತ್ತೆ. ದಿಸ್ ಕಾಂಟೆಂಪ್ಲೇಟ್ಸ್ 4 kinds of situations which we can classify and discuss in detail. First is one plaintiff, one defendant, and there are several causes of action. ಒಂದು ಪ್ಲೇಂಟಿಫ್ ಇರ್ಬೋದು, ಒಬ್ಬ ಪ್ಲೇಂಟಿಫ್, ಒಬ್ಬ ಡಿಫೆಂಡೆಂಟ್, ಒಬ್ಬ ಪ್ರವಾದಿ, ಒಬ್ಬ ಪ್ರತಿವಾದಿ. ಅದರಲ್ಲಿ ಸುಮಾರು ವ್ಯಾಜ್ಯದ ಕಾರಣಗಳು ಉಂಟಾಗಿರಬೇಕು. ಆವಾಗ ಯಾವ ರೀತಿ ಮಾಡಬೇಕು? 2 or more ಪ್ಲೇಂಟಿಫ್ಸ್, ಒಂದು ಡಿಫೆಂಡೆಂಟ್, ಇಬ್ಬರು ಪ್ಲೇಂಟಿಫ್ ಜಾಯಿನ್ ಆಗ್ತಾರೆ. ಇಬ್ಬರು ಪ್ಲೇಂಟಿಫ್ಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ರೂಲ್ 1 ಅವರಿಗೆ ಕಾಮನ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟ್ರಲ್ಲಿ, ಮತ್ತು ಅದನ್ನು ಡಿಸೈಡ್ ಮಾಡಬೇಕಾದ್ರೆ ಕಾಮನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬರಬಹುದು ಅನ್ನೋ ಪರಿಸ್ಥಿತಿ ಇದ್ದರೆ ಆ ಎರಡನ್ನ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಒಂದೇ ಸೂಟಲ್ಲಿ ಜಾಯಿನ್ ಮಾಡಿದರೆ ಒಂದು ಡಿಫೆಂಡೆಂಟ್ ಇರ್ತಾನೆ, ಒಂದು ಡಿಫೆಂಡೆಂಟ್ ವಿರುದ್ಧ, ಮತ್ತು ಸೆವೆರಲ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್. ಮತ್ತು ಸೆವೆರಲ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್, ಸುಮಾರು ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನು ಒಬ್ಬ ಪ್ಲೇಂಟಿಫು ಮತ್ತು ಅದಕ್ಕೆ ವಿರುದ್ಧ ಇಬ್ಬರು ಅಥವಾ ಜಾಸ್ತಿ ಪ್ರತಿವಾದಿಗಳು, ಆ ಥರ ಒಂದು ಸಿಚುವೇಶನ್ ಬರ್ಬೋದು. ಅಥವಾ ಇಬ್ಬರು ಅಥವಾ ಜಾಸ್ತಿ ಪ್ಲೇಂಟಿಫ್ಸು, ಇಬ್ಬರು ಅಥವಾ ಜಾಸ್ತಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ಗಳು. ಸೊ ಈ ರೀತಿ 4 ಸಿಚುವೇಶನ್ಸನ್ನು ನಾವು ಯಾವ ರೀತಿ ಜಾಯಿನ್ ಮಾಡಬೇಕು ಅಂತ ನೋಡೋಣ. ಫಸ್ಟ್ ಒನ್, ಜಾಯಿಂಡರ್ ಆಫ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್. ಸೊ ಇದನ್ನು ಮೊದಲು ಏನು ತಿಳ್ಕೊಬೇಕಂದ್ರೆ, ನಾವು ಸುಮಾರು ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್, ಸುಮಾರು ಕಾರಣಗಳು ಬಂದಾಗ ಒಂದು ಮೊದಲನೇ ಕಾರಣದಿಂದ ಕೆಲವು ರೆಮಿಡೀಸ್ ಅವನಿಗೆ ಹಕ್ಕು ಬಂದ್ಬಿಟ್ಟಿದೆ, ಕೆಲವು ಪರಿಹಾರಗಳು ಅವನು ಕೇಳ್ಬೋದು. ಇನ್ನೊಂದು ಕಾರಣ ಆಯಿತು, ಅದರಿಂದ ಇನ್ನೊಂದು ಅವನಿಗೆ ಹಕ್ಕು ಬಂತು. ಸೊ ಇವೆಲ್ಲನೂ ಸೇರಿಸಿ ಪ್ಲೇಂಟಿಫ್ ಒಬ್ಬ ಅಥವಾ ಇಬ್ಬರು ಪ್ಲೇಂಟಿಫ್ಸು ಜಾಯಿನ್ ಆಗಿ, ಅಂದರೆ ಆರ್ಡರ್ 1 ಅಲ್ಲಿ ಇರೋವಂಥ ಜಾಯಿಂಡರ್ ಆಫ್ ಪಾರ್ಟೀಸನ್ನು ಆರ್ಡರ್ 2ನಲ್ಲಿ ಇರೋವಂಥ ಜಾಯಿಂಡರ್ಸ್ ಆಫ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್, ಈ ಎರಡೂ ಸೇರಿ ಯಾವ ರೀತಿ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಪ್ರಾವಿಷನ್ಸನ್ನು, ಅದನ್ನು ನಾವು ಡೀಟೇಲಲ್ಲಿ ನೋಡೋಣ. ಮೊದಲನೇ ಸಿಚುವೇಶನ್, ಫಸ್ಟ್, ಸೊ ವಿ ಆರ್ ಡಿಸ್ಕಸಿಂಗ್ ಹೌ ಆರ್ಡರ್ 1 ಆ್ಯಂಡ್ ದ ರೂಲ್ಸ್ ಇನ್ ಆರ್ಡರ್ 1 ರಿಲೇಟಿಂಗ್ ಟು ಜಾಯಿಂಡರ್ ಆಫ್ ಪ್ಲೇಂಟಿಫ್ಸ್ ಆರ್ ಜಾಯಿಂಡರ್ ಆಫ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಆ್ಯಂಡ್ ಆರ್ಡರ್ 2. So order 1 and order 2, when we discuss together, what are the situations where we can join? We can join parties, we can join causes of action. How can we join both? What are the conditions and what are the restrictions on that? So first situation, there is one plaintiff, there is one defendant, and there are several causes of action. That is the situation. Then what can happen is plaintiff can unite several causes of action in the same suit. Okay, but rule 6 comes in. Rule 6 says that power of the court to order separate trials, where it appears to the court that the joinder of causes of action may embarrass or delay the suit or is otherwise inconvenient, the court may order separate trials or make such other orders as may be expedient to the interests of justice. Rule 6 ಆ ಥರ ಹೇಳುತ್ತೆ. ಜಾಯಿಂಡರ್ ಆಫ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಮಾಡಿರೋದ್ರಿಂದ ಸುಮಾರು ವ್ಯಾಜ್ಯದ ಕಾರಣಗಳನ್ನು ಸೇರ್ಪಡೆ ಮಾಡಿದಾಗ ಟ್ರಯಲ್ ತಡ ಆಗ್ಬೋದು ಅಥವಾ ಎಂಬ್ಯಾರೆಸ್ ಆಗ್ಬೋದು. ಅಂದರೆ ಟ್ರಯಲ್ ಸರಿಯಾಗಿ ನಡ್ಸೋಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ, ಆಗಲ್ಲ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ, ಅಥವಾ ಇದು ಅನುಕೂಲ ಆಗಿಲ್ಲ, ಇದು ಅನನುಕೂಲತೆ ಬರುತ್ತೆ. ಇದರಿಂದ ಈ ಪ್ಲೇಂಟಿಫ್ಸ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಜಾಯಿನ್ ಮಾಡಿದರೆ ಅಥವಾ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಒಂದೇ ಸೂಟಲ್ಲಿ ಜಾಯಿನ್ ಮಾಡಿದರೆ ಅಂದರೆ ಕೋರ್ಟ್ ಆವಾಗ ಆದೇಶ ಕೊಡುತ್ತೆ, ಸೆಪ್ರೇಟ್ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ಗೆ ಸೆಪ್ರೇಟ್ ಟ್ರಯಲ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಬೇರೆ ಅದನ್ನು ಭಿನ್ನ ಇದನ್ನು ಟ್ರಯಲ್ಸನ್ನು ವಿಚಾರಣೆಗಳನ್ನು ನೀವು ನಡೆಸಿ ಅಂತ ಹೇಳಿ ಕೋರ್ಟ್ ಆದೇಶ ಮಾಡಬಹುದು. ಅಂದರೆ ಪ್ಲೇಂಟಿಫ್ ಯುನೈಟ್ ಮಾಡಿದರೂ ಕೂಡ, ಪ್ಲೇಂಟಿಫ್ಸ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಒಂದೇ ಸೂಟಲ್ಲಿ ಮಾಡಿದರೂ ಕೂಡ ಕೋರ್ಟ್ಗೆ ಪವರ್ ಇದೆ. ರೂಲ್ 6 ಪ್ರಕಾರ ಕೋರ್ಟ್ ನೋಡಬೇಕು ಇದನ್ನು ಸರಿಯಾಗಿ ನಡೆಸೋಕ್ಕಾಗತ್ತಾ, ಈ ದಾವೆ ಸರಿಯಾಗಿ ನಡೆಸೋಕ್ಕಾಗಲ್ಲ, ಅಥವಾ ಇದು ತಡ ಆಗುತ್ತೆ, ಅಥವಾ ಇದು ಇಬ್ಬರು ಪಾರ್ಟೀಸ್ಗೆ ಸರಿ ಹೋಗಲ್ಲ, ಇದು ಅನುಕೂಲ ಆಗಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ಬಂದರೆ ಕೋರ್ಟ್ ಸೆಪ್ರೇಟ್ ಟ್ರಯಲ್ ಮಾಡಿ ಅಂತ ಆದೇಶ ಕೊಡ್ಬೋದು. ಮೀನ್ಸ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಎ ಕಂಪಲ್ಸರಿ ಥಿಂಗ್ ದಟ್ ಹಿ ಶುಡ್ ಯುನೈಟ್ ಸೆವರಲ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್. Understand that the plaintiff can unite, he may unite several causes of action in the same suit for the convenience. So if there is one plaintiff, he wants to sue another defendant and there are several causes of action, all the causes of action he will mention in the same suit, and he will unite all the causes of action along with the remedies and along with the claims which he has in each cause of action. That is first situation. So the second situation, there are two or more plaintiffs and there are several causes of action. Only one defendant, two or more plaintiffs, several causes of action. Then what can he do is, the plaintiffs together, see here the order 1 rule 1 comes in. That has to be read with order 1 rule 1, because when the plaintiffs are joined, on what condition the plaintiff should be joined? The plaintiff should be joined if they are all jointly interested. That is important. ಬೇರೆ ಪ್ಲೇಂಟಿಫ್ ಬೇರೆ ಇಂಟ್ರೆಸ್ಟ್ ಬೇರೆ ಹಿತಾಸಕ್ತಿ ಹೊಂದಿರೋದಿದ್ರೆ ಜಾಯಿಂಡರ್ ಆಫ್ ಪ್ಲೇಂಟಿಫ್ಸ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಸೊ ದ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಮಸ್ಟ್ ಹ್ಯಾವ್ ಅರೈಸನ್ ಫ್ರಮ್ ದ ಸೇಮ್ ಆ್ಯಕ್ಟ್ ಆರ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್. ನಾವು ಏನು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದೀವಿ ಆರ್ಡರ್ 1ನಲ್ಲಿ, ಒಂದೇ ವ್ಯವಹಾರದಿಂದ ಒಂದೇ ಕೃತ್ಯದಿಂದ ಆ ಎಲ್ಲ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ನು ಎಲ್ಲ ಪ್ಲೇಂಟಿಫ್ಸ್ಗೆ ಆಗಿರ್ಬೋದು. ಸಿ ಬೇರೆ ಸಮಯದಲ್ಲಿ ಆಗಿರ್ಬೋದು. ಇಟ್ ಈಸ್ ನಾಟ್ ದಟ್ ದೇ ವಿಲ್ ಬಿ ಹ್ಯಾವಿಂಗ್ ಅಟ್ ದ ಸೇಮ್ ಟೈಮ್, ಬಟ್ ಕಾಮನ್ ಕ್ವಶನ್ಸ್ ಆಫ್ ಲಾ ಆರ್ ಫ್ಯಾಕ್ಟ್ ಮಸ್ಟ್ ಹ್ಯಾವ್ ಬೀನ್ ಇನ್ವಾಲ್ವ್ಡ್. ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಾಗ ಸಮಾನ ಪ್ರಶ್ನೆ ಉದ್ಭವ ಆಗ್ಬೋದು. ಆ ಪ್ರಶ್ನೆಯನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ತಂದು ಅದರ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಮಾಡುವಾಗ ಎಲ್ಲ ಸಮಾನತೆ ಇರಬೇಕು, ಎಲ್ಲ ಸಾಮಾನ್ಯವಾಗಿ ಎಲ್ಲರಿಗೆ ಇಬ್ಬರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿರುವಂಥ ಪ್ರಶ್ನೆ ಬರುತ್ತೆ ಅಂದಾಗ 2 or more plaintiffs ಜಾಯಿನ್ ಆಗ್ಬೋದು. ದಟ್ ಈಸ್ ಆರ್ಡರ್ ಆಫ್ ಪಾರ್ಟೀಸ್. ದೆನ್ ದೇ ಕ್ಯಾನ್ ಜಾಯಿನ್ ಸೆವರಲ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಇನ್ ಒನ್ ಸೂಟ್ ಇಫ್ against the same defendant if they are all jointly interested in the cause of action. ಅದಕ್ಕೆ ಕಂಡೀಷನ್ ಏನಂದರೆ ಜಾಯಿಂಟ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಇರಬೇಕು, ಅವರ ಜಂಟಿಯಾಗಿ ಆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನಲ್ಲಿ ಹಿತಾಸಕ್ತಿ ಅವ್ರದ್ದು ಹೊಂದಿರಬೇಕು. If plaintiffs are not jointly interested in the several causes of action and the right to relief does not arise from the same act of or transaction, or where common questions of law or fact are not involved, suppose order 1 satisfy ಆಗ್ತಾ ಇಲ್ಲ, ಪ್ಲೇಂಟಿಫ್ಸ್ ಜಾಯಿಂಟ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಅಲ್ಲ, ಪ್ಲೇಂಟಿಫ್ಸ್ ಬೇರೆ ಇದರಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಗಿದೆ. ನಾನು ಒಂದು ಉದಾಹರಣೆ ಕೊಟ್ಟಿದ್ದೆ. ಈಗ ಸಪೋಸ್ ದ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಅಲಾಟ್ಸ್ ಹೌಸಸ್ to number of people. So when they join, suppose there are 2 or 3 plaintiffs, 2 or 3 people, and who are asked to pay extra amount. ಆ ಮೂರದ್ದು ಸೇಮ್ ಆ್ಯಕ್ಟ್ ಔಟ್, ಅದು ಬೇರೆ ಸಮಯದಲ್ಲಿ ಇರ್ಬೋದು. ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಬೇರೆ ಇದೆ. ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಯಾವಾಗ ಅರೈಸ್ ಆಗುತ್ತೆ, ಯಾವಾಗ ಡಿಮಾಂಡ್ ಬರುತ್ತೆ ಅಮೌಂಟ್ಗೆ, ಆವಾಗ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್. ವ್ಯಾಜ್ಯದ ಕಾರಣ ಯಾವಾಗ ಬರುತ್ತೆ, ಯಾವಾಗ ಕೋರ್ಟ್ ಯಾವಾಗ ಅಥಾರಿಟಿ ಅಮೌಂಟ್ ಕೇಳುತ್ತೆ. ಸೊ ಸಪೋಸ್ ದೇರ್ ಆರ್ ನಂಬರ್ ಆಫ್ ಪೀಪಲ್ ಆ್ಯಂಡ್ ದೇ ಹ್ಯಾವ್ ಅಪ್ಲೈಡ್ ಟು ದ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಫಾರ್ ಮನಿ, ಫಾರ್ ಎ ಸೈಟ್, ಆ್ಯಂಡ್ ದ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಹ್ಯಾಸ್ ಅಲಾಟೆಡ್ ದೆಮ್ site or house, whatever it is, and at different times it has asked for extra amount which was not there in the original contract. Now they get a cause of action. Cause of action is different. it is in different on different occasions the cause of action have arisen, but the relief, they are all jointly interested against that particular authority, and there is one defendant, that is that housing board, and the plaintiffs, that is those who are affected, they are all jointly interested in that case, in that one suit and in the cause of action. So in such cases order 1 is satisfied. Again, when it comes before the court, the common questions of law or fact will be coming into evidence. That is, what was the contract, what are the terms of the contract. Contract is only the same with the all the people who apply for the houses in the housing board. The contract is the same. So common questions of law has to be put before the court, common question of a fact are put before the court. Therefore it is a case where the plaintiffs may unite all the causes of action of all the plaintiffs in one suit and sue that one defendant, that is the housing board. You get that? So this can be done. But if it is that they are not jointly interested, suppose one plaintiff has applied for a house, and one other person, the same defendant may be there, he has filed on some other ground. Okay, that cause of action is not raising common law question of law or fact. It may be that he is challenging his right itself. He says that I have to be allotted the site on some other grounds. So that cause of action may be same, but cause of action may be same. Cause of action means the demand for money must have been done, it is at that particular time, that is okay. But the interest which is there in that suit is different. They are not jointly interested. So when it comes before the court, there are several different questions. That plaintiff will ask for some other, he will bring in some other evidence relating to some other rights. This person will bring in some other questions relating to some other rights. That means it is not coinciding with order 1, rule 1. So joinder of plaintiffs cannot be done in such cases. In such cases, if they join according to order 2, rule 2, then the case will be bad for misjoinder of plaintiffs and causes of actions. So the suit will be bad for misjoinder. Misjoinder ಆಗುತ್ತೆ, ಅದು ತಪ್ಪು ಸೇರ್ಪಡೆ ಅಥವಾ ಸರಿಯಾಗಿ ಸೇರ್ಪಡೆ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇದನ್ನು ಕೋರ್ಟು ಸೆಪರೇಟ್ ಟ್ರಯಲ್ಸ್ ಮಾಡಿ ಅಂತ ಕೇಳಬಹುದು. ಸೊ ದಿಸ್ ಇಸ್ ದ ಸೆಕೆಂಡ್ ಸಿಚುವೇಶನ್. ಥರ್ಡ್ ಸಿಚುವೇಶನ್, joinder of defendants and causes of action, like 2 or more defendants. One plaintiff ಇದ್ದಾನೆ, ಇಬ್ಬರಿಗಿಂತ ಜಾಸ್ತಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ. ಸೊ ಸುಮಾರು ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಇದೆ. ಆವಾಗ ಪ್ಲೇಂಟಿಫ್ ಅದನ್ನು ಸೆವ್ರಲ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಒಂದೇ ಸೂಟಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ವಿರುದ್ಧವಾಗಿ ಕೇಳ್ಬೋದು. ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಜಾಯಿಂಟ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇರಬೇಕು ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನಲ್ಲಿ. ಸೊ ಇಫ್ ದರ್ ಇಸ್ ಒನ್ ಪ್ಲೇಂಟಿಫ್, 2 or more defendants and several cause of action, the plaintiff can unite on the condition that the defendants are jointly interested in the cause of action subject to order 1, rule 3. Order 1, rule 3 speaks about joinder of defendants. Joinder of defendants. Are you getting this? So when defendants are to be joined, they have to look into the conditions there. What are the conditions? The relief claimed under order 1, rule 3, the relief which is claimed must have been based on the same act or transaction. Cause or transaction, cause of action arise ಮಾಡೋ ಸಮಯ ಬೇರೆ ಇದ್ರೂ ಕೂಡ ಆ ಆ್ಯಕ್ಟ್ ಏನಿದೆ ಅಥವಾ ಆ ವ್ಯವಹಾರ ಏನಿದೆ ಒಂದೇ ಆ್ಯಕ್ಟ್ ಇರಬೇಕು. So that on that ground, if there are 2 defendants, for example, I gave you an example about a accident where an accident takes place and one person is injured. So that one person is a plaintiff. Okay, he is injured. He can unite the causes of action in the same suit if the defendants are jointly interested. There are different defendants are there. Which are the defendants? That is the owner of that vehicle, or the person who is driving, or the insurance company. So the facts which are going to be coming before the court are the same, relating to that particular transaction or that particular act itself. Okay, and then 2 or more defendants can be joined. There may be several causes of action. So causes of action in the sense it has been the cause of action has arisen to the plaintiff by say by that injury, then again later on he is taken to the hospital, and then in the hospital he suffers some as a result of that injury he suffers some other complications. Again the cause of action arises relating to that, he gets again other reliefs. So under that cause of action he can claim for some other remedies also. So there are several causes of action against one plaintiff, and by one plaintiff, and there are more than one defendants, then all the causes of action can be joined. But if two or more defendants have been joined against order 1 rule 3, against order 1 rule 3 andre the relief claimed must have been based on the same act anta heltivilla. So it may be that the reliefs are not based on the same act. Once that same plaintiff, he has suffered an injury from the vehicle driven by A. On another occasion, he has suffered an injury by a vehicle driven by B. These are two different defendants, and the occasions are different, the transactions are different, and the cause of actions also are different. Then you cannot join. See, A and B I will join together and I will ask for injury, I will ask for my compensation or damages. That cannot be done, because if that is done, the suit is bad for misjoinder of defendants and causes of action. That is called as multifariousness. In the exam we can be asked a question, what is multifarious suits? Give an example, or they can say what are the conditions where multifariousness is caused, or just write a short note on multifarious suits. There you have to mention this particular thing: one plaintiff, two more defendants, two or more defendants, and several causes of action. They can be joined if the defendants are jointly interested in the cause of action. So a cause of action alli defendants ಪ್ರತಿವಾದಿಗಳು ಸಮಾನವಾಗಿ ಜಂಟಿಯಾಗಿ ಹಿತಾಸಕ್ತಿ ಹೊಂದಿರಬೇಕು. ಆಗಿಲ್ಲ ಹಿತಾಸಕ್ತಿ ಹೊಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ದೆನ್ ಮಲ್ಟಿಫೇರಿಯಸ್ನೆಸ್ ಆಗುತ್ತೆ. ಇದನ್ನು ಈ ಕೋರ್ಟು ಅದನ್ನು ನಡೆಸೋಕ್ಕೆ ನಿರಾಕರಿಸ್ಬೋದು, ಸೆಪ್ರೇಟ್ ಟ್ರಯಲ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೋದು. ಕಮಿಂಗ್ ಟು causes of action, that is the next fourth situation, where there are two or more plaintiffs, two or more defendants, and several causes of action. Plaintiff also they are more, defendants also are more, and several causes of action are there. Then the plaintiffs may unite the causes of action against the defendants in the same suit only when all the defendants, all the plaintiffs are jointly interested in the causes of action. ಒಂದೇ cause of action ಅಲ್ಲಿ ಎಲ್ಲ ಪ್ಲೇಂಟಿಫ್ಸ್ ಎಲ್ಲ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಜಂಟಿಯಾಗಿ ಹಿತಾಸಕ್ತಿ ಹೊಂದಿದ್ರೆ ಮಾತ್ರ ಇದನ್ನ ದಿಸ್ ವೆನ್ ಇಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಸ್ ವೆನ್ ದರ್ ಇಸ್ ಎ ಸಪೋಸ್ ದರ್ ಇಸ್ ಎ assault or there is a rally. At that time many people are injured. Okay, there are many defendants and there are many plaintiffs who are claiming out of that. In such cases, that is one cause of action or different causes of action. ಬೇರೆ causes of action ಇರ್ಬೋದು. ಆವಾಗ in the same suit they can join. Two or more plaintiffs, two or more defendants can be joined, and plaintiffs A and B, A, B and C versus defendants D, E and F, they can join. And several causes of action what is there has to be stated in the suit separately. So here let us discuss, as I said, multifariousness. What is multifariousness? Misjoinder of plaintiffs, defendants and causes of action. That is called as multifariousness. Multifariousness ಬಂದಾಗ ಕೇಸು ನಡೆಸಿದ್ರೆ ಅದು ಅನುಕೂಲ ಆಗೋದಿಲ್ಲ, ಮತ್ತು ಸುಮಾರು ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ಆಗಿ ಬೇರೆ ಎವಿಡೆನ್ಸ್ ಬರೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ. ಯಾಕೆಂದರೆ ಜಾಯಿಂಟ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇರೋದಿಲ್ಲ. ಒಂದು ಸೂಟ್ ಇದ್ದಾಗ ಆ ಸೂಟ್ ಯಾವ ರೀತಿ ಫ್ರೇಮ್ ಮಾಡಬೇಕು ಅಂದರೆ ಅದನ್ನು ಜಾಯಿಂಟ್ಲಿ ಡಿಸೈಡ್ ಮಾಡೋಕ್ಕೆ ಸಾಧ್ಯತೆ ಇರಬೇಕು. ಆಗ ಸೂಟು ಸರಿಯಾಗಿ ನಡೆಸ್ಬೋದು. ಈಗ ಇದರಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ಸ್ ವೆನ್ ವಿ ಸೇ ದಟ್ ಯು ಕ್ಯಾನ್ ಜಾಯಿನ್ ಪಾರ್ಟೀಸ್, order 1 says you can join parties, but when we can join parties, on what grounds we can join the parties, that is discussed in order 2. In order 2 we speak about the cause of action. So the cause of action, when it is the same, then there is no question about it. If the causes of action are different, then these three things are there. How misjoinder can be caused? If the plaintiffs are not jointly interested in the causes of action, the suit will be bad for misjoinder of parties and causes of action. ಪ್ಲೇಂಟಿಫ್ ಸರಿಯಾಗಿ ಆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನಲ್ಲಿ ವ್ಯಾಜ್ಯದ ಕಾರಣದಲ್ಲಿ ಜಂಟಿಯಾಗಿ ಹಿತಾಸಕ್ತಿ ಹೊಂದಿಲ್ಲ ಅಂತಂದರೆ ಸೂಟು ಮಿಸ್ಜಾಯಿಂಡರ್ ಆಗುತ್ತೆ, ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನು ಮತ್ತು ಪ್ಲೇಂಟಿಫ್ಸ್ದು ಮಿಸ್ಜಾಯಿಂಡರ್ ಆಗುತ್ತೆ, ತಪ್ಪು ಸೇರ್ಪಡೆ ಆಗುತ್ತೆ. ಇಫ್ ದ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಆರ್ ನಾಟ್ jointly interested in the causes of action, here it is plaintiffs, in the second case it is the defendants. If the defendants are not jointly interested, the suit will be bad for multifariousness. If neither plaintiffs nor the defendants are jointly interested in the cause of action, the suit will be bad for double misjoinder of parties. Plaintiffs illa defendants illa jointly. Causes of action ಅದರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಇದೆ. ಅದರಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ಸ್ಗೆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಬಂದಿರೋದು ಬೇರೆ, ಡಿಫೆಂಡೆಂಟ್ಸ್ಗೆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಬಂದಿರೋದು ಬೇರೆ. ಆ ಡಿಫೆಂಡೆಂಟ್ಸಲ್ಲಿ ಪ್ರತ್ಯೇಕ ಡಿಫೆಂಡೆಂಟ್ಗೆ ಬೇರೆ ಬೇರೆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್. ಆ ಪ್ರತ್ಯೇಕ ಅದಕ್ಕೆ ನಾವು ಅಂದರೆ ಪ್ರತ್ಯೇಕ ಡಿಫೆಂಡೆಂಟ್ಸ್ಗೆ ಆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನಲ್ಲಿ ಬೇರೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ. ಪ್ರತ್ಯೇಕ ಪ್ಲೇಂಟಿಫ್ಗೆ ಬೇರೆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಬಂದಿದೆ, ಅವ್ರದ್ದು ಇಂಟ್ರೆಸ್ಟ್ ಒಬ್ಬರ ಜೊತೆಲೇ ಮ್ಯಾಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅಂಥ ಸಮಯದಲ್ಲಿ ಎಲ್ಲ ಸರಿ ಒಂದು ಸೂಟಲ್ಲಿ ಹಾಕಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಇಟ್ ಬಿಕಮ್ಸ್ ಡಬಲ್ ಮಿಸ್ಜಾಯಿಂಡರ್ ಆಫ್ ಪಾರ್ಟೀಸ್. ಸೊ ದಿಸ್ ಈಸ್ ಒನ್ ಥಿಂಗ್ ವಿಚ್ ಹ್ಯಾಸ್ ಬಿನ್ given in order 2 rule 2 order 2 rule 3, where it is subject to rule 6 and it is subject to order 1 rule 1 and order 1 rule 3. Order 1 rule 1 you should remember for joinder of plaintiffs, order 1 rule 3 it is a joinder of defendants. These all these sections or all these provisions go together. So you have to discuss when you are framing, when the plaintiff is putting what you call as a plan as to how he can join his cause of action against that person. So there these things have to be considered by the plaintiff. So this is a summary of all this. Joinder of causes of action, a summary. This is for your reference because it will be easy for you to remember this when we are answering the questions where what is multifarious suits, it can be asked, or what are the provisions relating to joinder of causes of action. Here order 2 rule 2 is that order 2 rule 3 we are discussing, and then it is subject to order 1 rule 1 and order 1 rule 3. Now it has been I have just tabulated in this form. ಸೊ ಈ ಟೇಬಲ್ ಪ್ರಕಾರ ನಾವು ಈ ಸಮರಿನ ನೋಡ್ಬೋದು, ಸಾರಾಂಶವನ್ನು ನೋಡ್ಬೋದು. ಪ್ಲೇಂಟಿಫ್ ಒಬ್ಬ ಇದ್ದಾನೆ, ಡಿಫೆಂಡೆಂಟ್ ಒಬ್ಬ ಇದ್ದಾನೆ, ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಸುಮಾರಿದೆ. ಆವಾಗ ಇದನ್ನು ಯುನೈಟ್ ಮಾಡ್ಬೋದು, ಎಲ್ಲನೂ ಯುನೈಟ್ ಮಾಡ್ಬೋದು, ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಲ್ಲ. ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ಆರ್ಡರ್ 1 ರೂಲ್ 1ನಲ್ಲಿ ಇರೋವಂಥ ಕಂಡೀಷನ್ಸನ್ನು ಪಾಲಿಸಬೇಕು. ಸೊ ಇಫ್ ದರ್ ಇಸ್ ಒನ್ ಪ್ಲೇಂಟಿಫ್ ಆ್ಯಂಡ್ ಒನ್ ಡಿಫೆಂಡೆಂಟ್, several causes of action, they can unite all the causes of action in one suit. Plaintiff can unite. Only thing is he has to follow the conditions in order 1 rule 1 and order 1 rule 1, that is it should be arising out of the same act or transaction, and there should be the common questions of law and fact to be discussed in that particular case which comes before the case. Okay, if it is followed, it can be united. Second is 2 or more plaintiffs, 1 defendant, then several causes of action. They may unite if all plaintiffs are jointly interested. If not, if this rule is not followed, misjoinder of plaintiffs and causes of action. Then 1 plaintiff, 2 or more defendants, several causes of action may unite if all defendants are interested. Misjoinder of if they do not follow order 1 rule 1 and 3, then misjoinder of defendants and causes of action, that is multifariousness. Multifariousness means misjoinder of defendants and causes of action, or misjoinder of plaintiffs and causes of action. 2 or more plaintiffs, 2 or more defendants, several causes of action may unite if all plaintiffs and all defendants are jointly interested, and misjoinder of plaintiffs and defendants and causes of action, that is multifariousness. So when there is a condition where several instances happen, and during those instances that plaintiff gets a cause of action to sue. So, what is a cause of action? First of all, a cause of action. What is a cause of action? What is the meaning of cause of action? How do you say that there are several causes of action? See, there is no the definition of cause of action. When we look at, you can say that it is a bundle of facts which give a rise to a relief or to a remedy. A bundle of facts which give a rise to a action before the court. ಸುಮಾರು ಸಂಗತಿಗಳು ಬಂದಿದೆ. ಆ ಸಂಗತಿಗಳನ್ನು ಸೇರಿಸಿದಾಗ ಆ ವ್ಯಕ್ತಿಯನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ದಾವೆ ಫೈಲ್ ಮಾಡೋಕ್ಕೆ ಒಂದು ಹಕ್ಕು ಬಂದಿರುತ್ತೆ. ಅದನ್ನು ನಾವು ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಇಟ್ ಈಸ್ ಅ ಬಂಡಲ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್. ಇಟ್ ಈಸ್ ನಾಟ್ ಎ ಬಂಡಲ್ ಆಫ್ ಲಾ. ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, ಕಾನೂನಿನ ಪ್ರಶ್ನೆ ಅಲ್ಲ ಅದು. ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಫ್ಯಾಕ್ಟ್, ಸಂಗತಿಯ ಪ್ರಶ್ನೆ. ಸೊ ಏನೇನಾಗಿದೆ ಆ್ಯಕ್ಚುಲಿ ಅಂತ, ಇವಾಗ ಟೆನೆಂಟ್ ಇದ್ದಾನೆ, ಅವನು ಬಾಡಿಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ, ಅವನಿಗೆ ಸೂಟ್ ಫೈಲ್ ಮಾಡಬೇಕು. ಸಪೋಸ್ ದ ಟೆನೆಂಟ್ ಡಸ್ ನಾಟ್ ಪೇ ದ ರೆಂಟ್ ಆ್ಯಂಡ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಫೈಲ್. ಸೊ ದೆರ್ ಈಸ್ ಅ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್. ವಾಟ್ ಈಸ್ ದ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್? ಸಿ ದ ಫ್ಯಾಕ್ಟ್ಸ್ ವಿಚ್ ಅರೈಸ್ ದೇರ್. He makes a demand. According to the contract of the rent, the owner makes a demand, and at that time he does not actually refuse to pay, but he does not pay, or he refuses to pay on some ground. Suppose he makes a demand for a water bill. That is the second again cause of action. First he asks for the rent. Again he says that you pay the water bill. You have utilized water. The tenant keeps quiet. Cause of action again arises. He has a remedy before the court. He says that he is not paying the electric bill. It is going on. He has not kept the building in a good condition. He has not cleaned it. See, there are different facts which happen, and those facts are cause for this person to take an action. So these are a bundle of facts which gives rise to a right to that particular person to sue him. So that is called as a cause of action. So there are several cause of actions. He can join all that, file a case against the defendant, and mention all the cause of action in one particular suit. He need not file one suit for the first instance when the cause of action arose, the second instance when the cause of action arose, when the third instance, that is the third fact which when the cause of action arose, then it becomes different trials. So for the convenience, the court has said that, the CPC has said that they can join all the cause of action in one suit. Okay, this is separate from joining of parties. There joining of parties also can be done. How joining of parties can be done? In the same instance, ಈಗ ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಬೇಕಾದ್ರೆ, ಈಗ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಪ್ಲೇಂಟಿಫ್ ಇದ್ದಾನೆ. He is the owner of that. Now he has given this house to somebody to look after. Now that person also can be joined as a plaintiff, because he is responsible under that to collect the rent. He is responsible to collect the bills. So that person can be joined as a plaintiff, because both are commonly jointly interested. They have to be jointly interested. So here what happens, when we look into that particular facts, we come to know whether they can be joined or not. ಸೊ ಕೋರ್ಟ್ ಏನು ಮಾಡುತ್ತೆ, ಆ ಫ್ಯಾಕ್ಟ್ಸನ್ನು ನೋಡಿ, ಆ ಸಂಗತಿಯನ್ನು ನೋಡಿ, ಈ ಜಾಯಿಂಡರ್ ಆಫ್ ಪ್ಲೇಂಟಿಫ್ಸ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಮಾಡ್ಬೋದಾ ಆರ್ಡರ್ 1 ರೂಲ್ 3 ಪ್ರಕಾರ, ಅದು ನೋಡುತ್ತೆ. ಆರ್ಡರ್ 1 ರೂಲ್ 1 ಪ್ರಕಾರ ಪ್ಲೇಂಟಿಫ್ ಜಾಯಿನ್ ಮಾಡ್ಬೋದು, ಅದು ನೋಡುತ್ತೆ. ದೆನ್ ಇಟ್ ವಿಲ್ ಆಲ್ಸೋ ಲುಕ್ ಇನ್ ಟು ವೆದರ್ ದ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಆರ್ ಸೆಪ್ರೇಟ್ ಆರ್ ಒನ್. If it feels that there is a multifariousness, if the court comes to know that or finds out that there are different causes of action, yes, but the plaintiffs are not jointly interested, the defendants also are not jointly interested, but they are joined in one suit, then the court will say you have separate trials, because in this suit there are different facts, in another thing there are different facts, and there are different causes of action also. So there are different suits can be filed on this ground. So you you separate trials against the defendant separately, and it can order for separate trials. That is the importance. The court can order for separate trials under Rule 6. So that is the summary of this particular provision. Coming to the next provision. Now here Rule 7 comes in. Rule 7 is that suppose a person files a case and the defendant wants to take an objection on the ground of misjoinder of causes of action. When should it be taken? See, here also, as I said, relating to misjoinder of parties may not frustrate the suit. It may frustrate the suit also. Misjoinder of parties ಮಾಡಿದರೆ ಪಾರ್ಟೀಸ್ ಯಾರು ಬೇಕು ಪ್ರಾಪರ್ ಆ್ಯಂಡ್ ನೆಸರಿ ಪಾರ್ಟಿ ಅವ್ರನ್ನ ಸೇರಿಸಲೇಬೇಕು. ಅವ್ರನ್ನ ಸೇರಿಸಿಲ್ಲ ಅಂದರೆ ಅದು ಕೋರ್ಟ್ ಹೇಳ್ಬೋದು ಸೇರಿಸಿ ಅಂತ ಹೇಳಿ. ಇಲ್ಲಿ ಅದು ನಾನ್ ಜಾಯಿಂಡರ್ ಆಗುತ್ತೆ. ಮಿಸ್ಜಾಯಿಂಡರ್ ಅಂತ ತಪ್ಪಾಗಿ ಯಾರಿಗೆ ಸೇರಿಸಬೇಕಾಗಿತ್ತು ಅವ್ರನ್ನ ಬಿಟ್ಟು ಬೇರೆಯವ್ರಿಗೆ ಸೇರಿಸಿದ್ರೆ ಮಿಸ್ಜಾಯಿಂಡರ್ ಆಗುತ್ತೆ. ಅದೇ ರೀತಿ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನು ಅಷ್ಟೇ. ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್, ಯಾವ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನಲ್ಲಿ ಆ ಪ್ಲೇಂಟಿಫ್ ಜಾಯಿಂಟ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇದ್ದಾರೆ ಅಥವಾ ಆ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಜಾಯಿಂಟ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇದ್ದಾರೆ, ಅದನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ನು ಮತ್ತು ಸುಮಾರು ಪ್ಲೇಂಟಿಫ್ಸು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಬೇರೆ ಬೇರೆ ಇದರಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇದ್ದಾರೆ, ಜಾಯಿಂಟ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇಲ್ಲ ಅಂತ ಅಂದಾಗ ಮಿಸ್ಜಾಯಿಂಡರ್ ಆಫ್ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಆಗುತ್ತೆ. ಅದನ್ನು ಅಬ್ಜೆಕ್ಷನ್ ಯಾರು ತಗೋಬೇಕು? ಸೊ ದ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಕ್ಯಾನ್ ಟೇಕ್ ದ ಅಬ್ಜೆಕ್ಷನ್, ಬಟ್ at the earliest opportunity or where it is the case has to be posted for settlement of issues. ಕೋರ್ಟ್ ಏನು ಮಾಡುತ್ತೆ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟು ಮತ್ತು ಇದನ್ನು ವಾದಪತ್ರ ಮತ್ತು ಪ್ರತಿವಾದ ಪತ್ರ ಎರಡೂ ಬಂದಾಗ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡುತ್ತೆ. ಇಶ್ಯೂಸ್ ಯಾವ್ಯಾವುದು ವ್ಯಾಜ್ಯದ ಇದು ವಿವಾದಗಳು ಇದೆ, ಆ ವಿವಾದದ ಪ್ರಶ್ನೆಗಳನ್ನು ಲಿಸ್ಟ್ ಮಾಡುತ್ತೆ ಕೋರ್ಟು. ಅದಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಫ್ ಇಶ್ಯೂಸ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಸೊ ಸೆಟಲ್ಮೆಂಟ್ ಆಫ್ ಇಶ್ಯೂಸ್ ಮಾಡೋ ಟೈಮಲ್ಲಿ ಅಥವಾ ಆ ಸಮಯದಲ್ಲಿ ಅಥವಾ ಆ ಸಮಯ ಮುಂಚೆ ಈ ಆ್ಯಕ್ಷನ್ ತಗೋಬೇಕು ಅಥವಾ ಈ ಅಬ್ಜೆಕ್ಷನ್ ತಗೋಬೇಕು. ಅದರ್ವೈಸ್ ದೇ ವಿಲ್ ಬಿ ಡೀಮ್ಡ್ ಟು ಹ್ಯಾವ್ ಬೀನ್ ವೇವ್ಡ್. What happens is, ground of objection, if it has arisen subsequently, suppose in that case he has already filed and later on some objection he has to take, so then the objection has arisen subsequently ಅಂತ ಹೇಳಿದಾಗ ನಂತರ ಬಂದಿದ್ರೆ ಆ ನಂತರ ಬಂದಿರೋ ಗ್ರೌಂಡಲ್ಲಿ ಅವನು ಅಬ್ಜೆಕ್ಷನ್ ನಂತರ ತಗೋಬಹುದು. ಬಟ್ ಆಸ್ ಫಾರ್ ಆಸ್ ಪಾಸಿಬಲ್ ದ ಅಬ್ಜೆಕ್ಷನ್ ಶುಡ್ ಬಿ ಟೇಕನ್ ಅಟ್ ದ ಅರ್ಲಿಯೆಸ್ಟ್ ಅಪರ್ಚುನಿಟಿ. ಮೊದಲನೇ ಅವಕಾಶ ಸಿಕ್ಕಿದ್ದಾಗ, ಮೊದಲನೇ ಫಸ್ಟಾಗಿ ಆದಷ್ಟು ಬೇಗ ಅವಕಾಶ ಸಿಕ್ಕಿದ ತಕ್ಷಣ ಈ ಆಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡಿದ್ರೆ ಮಾತ್ರ ಕೋರ್ಟ್ ಅದಕ್ಕೆ ಅಲೌ ಮಾಡುತ್ತೆ. ಅದರ್ವೈಸ್ ಇಟ್ ಈಸ್ ಡೀಮ್, ಅದು ಇಲ್ಲ ಅಂತಂದರೆ ನಿಮ್ಮ ಹಕ್ಕನ್ನು ವೇವ್ ಮಾಡಿದ್ದೀರಾ ಅಂತ ಕೋರ್ಟ್ ಭಾವಿಸುತ್ತೆ. ಸೊ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ವೇವ್ಡ್. It will be deemed to have been waived and then the court will take up the matter and the matter will be decided unless the court itself orders under Rule 6. If the court does not order under Rule 6, under Rule 7 objection can be taken, but it has to be taken at the earliest opportunity or before the settlement of issues. Yes, have you understood this? So this is a complete discussion about how the suit should be framed. Now we are filing a suit before the court. How it has to be framed, how the plaintiffs have the parties have to be joined, how the causes of action have to be joined, how the remedies have to be claimed before the court, what are the remedies, and that remedies also have to be taken together. So we have discussed the essentials of the suit. That is, first is the parties, then the subject matter which is in dispute, that is and then the claims, that is the cause of action, and then the relief. So whatever these things are there, how to frame and put all this together and file a suit, that is the object of order 1 and order 2. Okay, now after that another actually filing the suit. Now actually filing the suit in the sense, what is the procedure of filing? What is the procedure of filing? That we discuss under section 26 and order 4 rule 1. These go together. Section 26 speaks about the substantial part, that is every suit must be instituted by the presentation of a plaint. Order 4 rule 1, when we join these, what is the provision is, every suit must be instituted by a presentation of a plaint in duplicate. So what is the procedure? ಈ ಪ್ರಕ್ರಿಯೆ ಏನಿದೆ ಅದನ್ನು ಆರ್ಡರ್ 4 ಹೇಳುತ್ತೆ. ಸೊ presentation, a suit means what? A suit is a proceeding which is instituted by presentation of a plaint. Plaint ವಾದಪತ್ರ ಇದ್ದರೆ ಅದನ್ನು ಸೂಟ್ ಅಂತ ಹೇಳ್ತೀವಿ, ಅದನ್ನು ದಾವೆ ಅಂತ ಹೇಳ್ತೀವಿ. ಆ ದಾವೆ ಪ್ರೆಸೆಂಟ್ ಹೇಗೆ ಮಾಡಬೇಕು, ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಹೇಗೆ ಮಾಡಬೇಕು, ಅಲ್ಲಿ ನಾವು ಫೈಲ್ ಮಾಡಬೇಕು ಕೋರ್ಟಲ್ಲಿ. ಒಂದು ಪ್ಲೇಂಟ್ ಡುಪ್ಲಿಕೇಟಲ್ಲಿ ಒಂದೇ ಇದನ್ನು 2 ಕಾಪೀಸ್ ಮಾಡಿ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟೆಡ್. or in such other manner as may be prescribed by the code. ಈ ಕೋಡಲ್ಲಿ ಮತ್ತೆ ಬೇರೆ ಏನಾದರೂ ಮ್ಯಾನರ್ ಹೇಳಿದರೆ ಅದ್ರ ಪ್ರಕಾರ ಯಾರು ಮಾಡಬೇಕು? Who has to file? By the plaintiff himself. Himself means it may be through his through anybody who is recognized by who is his recognized agent, or by his recognized agent, or by any person duly authorized by him. A person duly authorized by him may be his advocate, may be his lawyer. So the person plaintiff himself may file, or his recognized agent may file, or any person duly authorized by him may file the suit. It can be instituted. Next, what is the time and place of presentation? Here the plaint must be presented where? To the court or such officer as it appoints in that behalf. In the court there is a particular section where there is an officer who is appointed to take the to accept the plaint at a particular time. You have to go there and present it to that officer. There is a specific place in every court, and the plaint has to be presented there. What time? On a working day, during office hours. During office hours. But suppose the working day is on a Saturday, and office hours, during the office hours, that is the time of the court, but the cause of whatever the limitation is there to that particular plaintiff, that expires on that working day, let us say, and or it is he is late, a little bit late in getting all the things done and getting it ready, and the time is that time expires, and if he is not allowed to file it, he may lose his right because the limitation is over. Or if it is a Sunday, of course if it is a Sunday, the next day will be the working day when he can file. But suppose that limitation is over, then there is no such thing which is stated, but the courts have held that, the courts have held in the different cases that a judge may accept a plaint at his residence also, or any other place, even after office hours. Even in the court after office hours, if the limitation is going to be lapsed after that, you can present it before the court saying that it is the last day of limitation, and the judge will accept. He may accept, not that he shall, even after office hours, though he is not bound to accept it. He is not bound to accept, but normally the judge will accept if it is the last day of your limitation. Okay. Then after it is accepted, this is when if it is after office hours, then you have to take the permission of the judge and you have to present it. Otherwise you can present it to the court, to that officer. Once it is presented to the officer, then particulars of the suit will be entered by the court in the register of civil suits. See, earlier we used to have manual registers, physical registers, where we used to present the plaint, and the plaint, the details of that, see what is the relief which has been claimed, and what is the, for what purpose it has been filed, who are the parties, that would be entered in that register, and they would give you the date later on. Now it is computerized, so there and then it will be entered. This is not stated in the CPC, but that is a practical thing which we should know. Okay, it will be entered in the by the court in the register of civil suits. After the presentation, the plaint will be scrutinized by the stamp reporter. There is a person who will scrutinize the plaint, and he will see if there is any defects relating to stamps. Suppose you have stamped it less, you have paid less duty, you have paid less court fees, or whatever is to be paid has not been, or the presentation has not been done in a proper manner, or there are any defects. He will bring it to the notice of the person who is presenting, and that plaintiff who is presenting will remove those defects, correct it, and he will put it before the officer, and then the suit will be numbered. After all this checkup is done, after all these things are done, it will be given a number. For example, OS number 451 of 2020, like that. It will be, the number will be given to the suit, and that number will be notified to that person. Okay. So this is the way of the time, the particulars which has to be given. There is one more thing which it says that every plaint must contain necessary particulars order 4 rule 2 says that every plaint must contain necessary particulars. Now, what are the necessary particulars to be given in the plaint? That will be the thing which we will be studying under order 6, that is the pleadings. When we study about pleadings, what are the things which should go in the plaint? So, plaint should state all the facts on basis of which the plaintiff has claimed his right or claimed his remedy. So, what are the particulars, how they have, you need not give evidence in the plaint, you need to give all the facts. So, all the necessary particulars, what are those necessary particulars, you have to understand, and you have to present the plaint. There is one, see, suppose a suit is filed by a person who is indigent or who is poor, who is a pauper. There is a particular provision, order 33 of the code, under which he has to take the permission of the court first. Suppose it is a suit is filed. Yes, Murli has asked a question, are the proper scrutiny of plaints being done properly? Of course, they are done properly, Murli. It is the plaints when they are presented to the office, they don't give you a number immediately. They first give you a FR number, that is a filing number. The filing number will be given to you saying that you have been, the plaint has been taken. Okay, then they will scrutinize. It is not that just in front of you they will look at it. In all the courts, yes, Murli, in all the courts, in lower courts, in higher courts, in all the courts, the scrutiny of the plaints has to be done. It will be done. Surely it will be done, because there is an officer for that purpose, and that person is given the responsibility of scrutinizing. See, he will not look into the facts, whether the facts are stated properly or not. The scrutiny will be done according to what are the things necessary to be in the plaint. According to that, he will look into. There are rules for that purpose. There are court rules, civil court rules, civil rules of courts, and criminal rules also are there. Civil rules of practice and criminal rules of practice. Under the civil rules of practice, which are framed by the high courts of that state, there are conditions given, there are all the instructions given in those rules. Now, how the plaint has to be presented, how the application has to be presented, what are the fees to be given, what is the stamp to be paid, all those things are looked into. They will not look into whether your fact is true or false. That is the next thing which the court will decide. You understand? But this is only the scrutiny will be done properly, and if that scrutiny is not done properly, that person will be held responsible. Scrutiny will be done. After that, if any defect is there, immediately the next time when you of course, now it is computerized, the number is also notified through your phone or through a message on your phone. Now the new guidelines say that you need not go particularly to the court because of this COVID situation. We are not going there. So, we get the messages of the what is the number of our suit. We get it on our phone itself, and it is notified. The proper the officer gets the number done, he gets the signature done by the judge of that particular court, which court it goes also. Suppose there are four courts, say suppose a civil judge, you are filing it before the civil judge, junior division. In junior division there are 10 courts. So, in which court it has to be sent, that also it goes before that particular court, and that judge decides the particular conditions relating to the stamps and everything. It is scrutinized by that person, that is the officer, and then finally it is allotted to a proper court. The number, it is numbered, and then you are notified of that, which court you have to appear at the next hearing, or when is the first hearing. All those things we will be discussing. How after filing, what are the next procedures, that we will be discussing in the future classes. Okay. So, it is done, the scrutiny of a plaints is done. It is done properly. It is according to the civil procedure code. All these things these are all technical provisions which have to be followed. What we have discussed till now, CPC is a very, very technical code. It has, though it has come in 1908, always those provisions are mandatorily followed in the courts. Now the matter is to be it is open to criticism, that people say that it is not done properly, or it is not the people do. See, what happens is the negligence or not doing it properly, that is a wrong on that part of that person, he will be liable for that. That is one thing. But according to the CPC, all the things are done, and it is it has to be mandatorily done. That is why we have to follow these orders and the sections mandatorily. We should know about this, which order, which section, and which has been violated, which has not been followed. So as when you practice as a lawyer, you need to know all this in details, in detail actually. Okay. So this is, any questions, any other questions, anybody else? So we have completed the study of institution of suit, how the suit is instituted, and in the next class we will go to the other provisions. That is, first of all we will discuss about pleadings, because now we need to know what are the, of course we are also studying a different subject relating to drafting, pleadings and conveyancing, where the actual drafting will be done by all the students. But we are going to discuss about what is a pleading, what is the object of pleading, what are the different provisions relating to the pleadings also. Yes, Suresh has asked a question, is the same cause of action is related same territorial and pecuniary jurisdiction? Yes, Suresh, according to the cause of action, where the cause of action has arisen is a very important fact, because cause of action is a bundle of facts, I said. So it is a fact. So where it has arisen. Now there, when you are speaking about filing it in a particular court, first thing has to be looked is whether that court has territorial jurisdiction and pecuniary jurisdiction. Okay, if that court does not have pecuniary jurisdiction, then if he can, as I said, he can relinquish his claim. I said that he can relinquish his claim and bring it down to a smaller claim and present it, but he will not be allowed to sue for that same claim. But he can file it in the higher court, which court has the pecuniary jurisdiction. The same cause of action, it is this whatever we have discussed today, it is a thing which has to be followed before any court. First thing you have to look into whether the court has jurisdiction, territorial jurisdiction, pecuniary jurisdiction, subject matter jurisdiction. Then you have to look into framing of the suit, how you are going to frame it, where you are going to file, that the jurisdiction decides, in which court you are going to file. So as I said just now, junior civil court junior division. So junior division has a pecuniary jurisdiction. Then you go to senior division, that has a higher pecuniary jurisdiction. Then you go to the district court. So it depends on the pecuniary jurisdiction. Again territorial, suppose that thing has a cause of action arises in Mysore, you have to file it in Mysore court only. If that cause of action has arisen in Mysore and the person is residing somewhere else, then according to the rules which we discussed about the cause of action, where the defendant resides or where that cause of action has arisen, either of the place you can, so you have to, it is subject to again section 15, 16, 17, 18, 19, 20, okay, all that. So 20, again 21 also we said, section 21 again we discussed about when the objection can be raised and how the court will decide. Then 21A also we have discussed. So this is subject to all that. Jurisdiction has to be looked into. Then the second subject which we have discussed, the topic which we have discussed is framing of suit. So how the suit has to be put before the court and what are the things which should go along with that, that we have discussed. Any other question? Have you understood this? Okay. So we will stop here and we will discuss about the pleadings. We will go to pleadings and all the necessary essentials of pleadings. What should be there in a pleading? What is the meaning of pleading? And how we are going to put all the facts in the pleading. What are the facts which we should put, and what is not allowed or what is not necessary? All those things in detail we will discuss, because these are the very, very important provisions which we have to look into. Thank you very much. काय म्हणला?
नाही त्याचं